Hello students, just 2 days for your examination so we can have a fast track revision into your paper 13 corporate and economic laws. So as usual, first we will discuss the topic dividend. So we know that dividend is after tax profit which is distributed to shareholders as a percentage on face value. We have two types of dividend. Number one is final dividend. Number two is interim dividend. So we know that final dividend is the dividend which is recommended by board of directors and approved or declared by members at general meeting, which can be AGM or EGM. Okay, then with respect to the sources of final dividend, we can have two sources. Number one is profit after providing depreciation as per Schedule 2 of Companies Act. Then from current financial year, preceding financial year remaining undistributed or out of both, or the amount given by central government or state government in pursuance of any guarantee given by it. Then number two, interim dividend. Interim dividend is a dividend which is declared by board of directors during a financial year or during the period from the end of the financial year till AGM or between two AGM. Then the sources of interim dividend can be surplus in P&L account, profit of the financial year in which dividend is sought to be declared, of which dividend is sought to be declared, or profit in the quarter immediately preceding date of declaration of interim dividend. Okay, then we can have the procedures of the declaration of final dividend. Once board is recommending the final dividend, it will be approved by members. After approval, it will be transferred to a separate scheduled bank account within 5 days of declaration, which is explained in section 123 subsection 4. Dividend has to be paid within 30 days of declaration. See, you have to understand, declaration of dividend is not mandatory, but once dividend is declared, it has to be paid within 30 days of declaration. If dividend is not paid within 30 days of declaration, the company directors who are knowingly a party to default will attract penal provision under section 127, which will be 1000 per day penal provision, penalty of 1000 per day, and uh, up to 2 years imprisonment. This penal provision can be avoided by the concerned person if the non-payment was due to some specified reason. Due to some specified reasons, number one, if it was due to operation of any law, if shareholder has given any instruction, direction regarding payment of dividend which the company could not comply and the same is communicated to shareholder, if there is any dispute on the part of shareholders or right to receive dividend, there is some problem with regard to that, the amount of dividend can be lawfully adjusted from any amount receivable from the part of shareholder, or if the non-payment is not due to any default on the part of company. Then if the dividend declared is not paid within 30 days of declaration, in the next 7 days it has to be transferred to unpaid dividend account. That unpaid dividend account will remain there for 7 years. Sorry, the amount of unpaid dividend will remain in UDA for 7 years. So once it is remaining for 7 years, it will be transferred to IEPF, which is constituted under section 125 of Companies Act 2030. Then now we can have a discussion on the topic Insurance Act 1938. So with respect to insurance, first we will discuss the principles of insurance. There are 7 common principles at most good faith, which specifies that the insurer and insurer, both the parties, to give clear and concise information regarding terms and conditions. Insurable interest means the subject matter of the insurance to provide gain when it exists and to incur loss when it is lost, destroyed, damaged, or stolen. Then proximate cause means nearest cause will be taken if the insurance is not insured against all the causes. Then indemnity, the insurer indemnifies, guarantee the insured to restore to the previous position. Subrogation, after the contract of indemnity, after indemnifying, the ownership of scrap or pieces will pass on to the insurer. Then contribution, the insured can claim compensation, the insured can claim indemnification only up to the actual loss. Then insured will have to take all the necessary steps to minimize the losses. Then minimum paid up requirement, which is specified under section 6 of Insurance Act. Life or general, it will be 100 CR, health exclusively 100 CR, reinsurance 200 CR. So please note that while computing the minimum paid up requirement under section 6, you will have to deduct the preliminary expenses. Now we'll move to the loans provision by insurance companies, which is explained in section 21. Section 21 subsection specifies that insurance company cannot provide loan to its directors, managers, auditors, actuary, or any other entity in which these persons hold such position. But insurance company can give insurance company can give loan to their policy holders on surrender of life insurance policy. So it is allowed on surrender value on security of life insurance policy. Then loan can be given by insurance company to banking company. It can be given to holding or subsidiary company with the approval of IRDA. Then now with respect to nomination, nominee minor sorry nomination is applicable for life insurance company. Minor can also become nominee. You can change nominee at any time before expiry of policy. In the case you are appointing a minor as nominee, appointee, a person who will be able to receive the benefits, will have to be appointed. Then we'll move to section 64 VB. Section 64 VB specifies that the risk can be assumed only after premium is guaranteed, received, or received in advance. Now we can move to section 45 of Insurance Act 1938, which specifies the questioning of life insurance policy. So life insurance policy cannot be called in question after 3 years. After 3 years from the date of issue, date of commencement of risk, date of revival, or date of rider, whichever is later. So it can be questioned within 3 years on ground of fraud or misrepresentation or suppression of fact. If it is questioned within 3 years on ground of fraud, it will be repudiated. There is no need to pay the paid premium. The company need not pay the paid premium to the policy holder, but in case of misrepresentation or suppression of fact, the premium will have to be paid in 90 days. Okay, then now we'll move to the provision of Banking Regulation Act 1949. So it specifies that the use of bank, banker, banking company under section 7. So no banking company can operate its business unless they are using the term bank, banker, or banking company. It cannot be used by any other entity except a banking company. But in certain circumstances, the act is giving relaxation that it can be used by association of bank, or it can be used by a subsidiary. Subsidiary of bank can specify that it is subsidiary of that particular bank. Then section 9 specifies the disposal of non-banking asset, which will have to be disposed within a period of 7 years. That means they can hold immovable property which is acquired for a maximum of 7 years. After 7 years, it will have to be disposed. Okay. So if there is any issue with regard to disposal, they can apply to RBI, and RBI will be giving maximum 5 years extension. Maximum 5 years. It is not that RBI will give 5 years, maximum of 5 years. So we'll move to section 17 of Banking Regulation Act, which specifies reserve fund. Keeping of reserve fund, maintaining of reserve fund is mandatory for every banking company, whether it be Indian company or foreign banks. It will have to maintain 20% as reserve fund, or they will have to transfer 20% to reserve fund. So RBI has wide its circular specified 25%. Bank will have to, that has requested all the banks to transfer 25%. If any bank is proposing to transfer less than, they can do the same on central government approval. By they can make an application to RBI. RBI will recommend to central government. Central government will be approving only if the amount in reserve fund and share premium account is not less than paid up capital. Then cash reserve ratio of non-scheduled bank, which is explained in section 18 of Banking Regulation Act, it is 3% of time and demand liabilities. Then SLR, statutory liquidity ratio, 25%. Then they have to maintain at least 75% as their assets. Okay, time and demand liabilities, 75% should be their assets. Then now we'll move to the provisions of appointment and qualification of directors under Companies Act 2013. So with respect to minimum and maximum directors, in one person company, there should be minimum 1 director, private company 2 directors, public company 3 directors. Across all the company, the maximum limit is 15. The limit of 15 can be exceeded by passing special resolution. The maximum limit and passing of special resolution is not required for government company, Section 8 company which has not defaulted in filing annual return or financial statement with ROC. Now we'll move to the type of directors. There are broadly three classification of directors. Number one, directors who are specified in articles, appointed by members, appointed by board of directors. Appointed by, specified in articles of association, it is first director. So first director who are specified in articles of association, regulation 60 is the regulation which is dealing with first directors. If regulation 60 is not applicable to a company, or if they have not appointed the first directors and regulation 60 is applicable, the first directors will be determined by majority of subscribers. If regulation 60 is not applicable to that company, all the subscribers who are individuals shall deem to be the first directors. Then we can have a discussion on the directors who are appointed by members. Number one, Indian resident director, which is applicable to all company, every company to have at least one director who stays in India for a period of 182 days or more in the financial year. Then woman director is applicable to listed company and unlisted public company having paid up 100 crore or above, or turnover 300 crore or above. Small shareholders director, shareholder holding face value not exceeding 20,000 is known as small shareholder. So in a company, you are taking the total of small shareholders, 10% or 1,000, whichever is less. You will be taking that value. That number of shareholders can apply to the company to appoint a person as their director, small shareholders director, or the company can appoint small shareholders director suo motu. The tenure will be 3 years. Then independent director provision will be applicable to listed company, then unlisted public company having paid up 10 crore or above, turnover 100 crore or above, or outstanding loan debenture deposit in excess of 50 crore. Then we have the directors who are appointed by board of directors. Additional directors are the directors appointed by board if authorized by articles of association. Their tenure will be till the next AGM or the last date on which AGM was to be conducted, whichever is earlier. Then if director moves out of India, leaves out of India for 3 months or above, and if the director is not able to attend any board meeting, the board of directors will appoint a director as alternate director. It is not alternative director. Please note, it is alternate director. Then nominee director. So these provisions are explained in section 161. So additional director subsection 1, subsection 2, nominee director subsection 3, and filling of casual vacancy subsection 4. So nominee director are the directors who are nominated by third parties, any bank, financial institution, etc., and who are appointed by board of directors. In case of any casual vacancy in the post of directors who are appointed by members, please note, if there is any casual vacancy in the post of any director who are appointed by members, that vacancy can be filled by board of directors. And you have to note that if any board of director is appointing a director, suppose alternate director is appointed, in case of the casual vacancy, that cannot be filled by board itself. Okay, so casual vacancy can be filled by board only when the appointment is made by members. So in case of a director who is appointed by members, board can fill that casual vacancy. Then now we can have the discussion on rotational, non-rotational director. So this is applicable to public company only. The provision is applicable to public company. The provisions are section 152, subsection 6, subsection 7. So minimum 2/3 of the total directors to be rotational in public company. Out of that rotational category, 1/3 of directors to retire. They can be either reappointed, some other persons can be appointed, or company can decide to leave that position vacant. Now we can have the discussion on 164. Disqualification of directors, 164 subsection 1, personal disqualification, disqualification on the basis of default by company, then additional disqualification. So we'll discuss. We know that personal disqualification, you know it very well. So we'll have a discussion on disqualification on the basis of default by company. So if a person is director, has been director of a company which has committed certain defaults, will be disqualified for a period of 5 years. So what are that particular defaults? If the company failed to file annual return or financial statement for 3 consecutive financial years, or if the company failed to pay interest on deposit, or failed to repay deposit, fail to pay interest on debentures, or fail to redeem debentures, or fail to pay declare dividend, and the failure continues for 1 year or above, that particular directors who were director at that time, who are directors at that time, or who were directors during the time of default will be disqualified for a period of 5 years. Okay, then additional disqualification can be prescribed only by private company. This is not applicable to public company. Additional disqualification 164 subsection 3 is applicable only to private company. Now we have vacation of office 167 subsection 1, which specifies this time period or the certain circumstances period under which a director have to vacate the office, like when he incurs disqualification under 164, when he absents from all board meeting during the period of 12 months, when he contravenes section 184, when he failed to disclose interest, then when he is disqualified by an order of court or tribunal, then convicted for any offense involving moral turpitude or otherwise, then when he is removed and in pursuance of the act or under 169, or when he is appointed in holding company or subsidiary company, sorry, when he is appointed as director because of holding any employment and that employment ceased. Now we can have the discussion on resignation of director. Director can resign by intimating the company in writing. Okay, the company has to file form DIR 12. If it is not filed, the director has to file DIR 11. Okay, the resignation shall take place from the date of intimation or the date which is specified, okay, which is specified in the intimation or the date of receipt of intimation by the company. Then now removal of directors. A director can be removed by passing ordinary resolution. So for taking up the discussion, a special notice under 115 has to be passed. After that, it will be discussed in meeting and the director can be removed by passing ordinary resolution. If the director is appointed by special resolution will be required for removal. Then 160, right of persons other than retiring director to stand for directorship. A person can stand for directorship. 1 lakh or such higher amount has to be kept as deposit. If the person get elected or if he secures more than 25% of the valid votes, that amount will be refunded. Otherwise, the amount will be forfeited. Then appointment of 2 or more directors in single resolution, section 162. This is not possible. In general meeting, you cannot appoint 2 or more directors through single resolution. You have to appoint in different resolution. But this is possible by complying 2 steps. So number 1, approval of all the members with no votes being casted against and passing of ordinary resolution. Then we have the provisions related to director identification number. A person cannot apply, obtain or possess more than 1 DIN. DIN cannot be cancelled, surrendered, deactivated except in certain circumstances. Just like if it is duplicated, it will be merged. If it is obtained in wrongful manner or fraudulent means, it will be cancelled, death, insolvency, unsound mind, etc. Okay. Then meetings of board and its powers. With respect to meetings of board, we can have the discussion on number of board meetings. So with respect to OPC, small company, dormant, startup, private, minimum 1 board meeting in calendar year half and gap should not be less than 90 days. With respect to other companies, minimum 4 board meetings in a calendar year and gap should not exceed 120 days. 120 days is maximum. Okay, so one is not less than 90 days. Minimum 90 days gap should be there. So with respect to other companies, it should not be exceeding 120 days. So mode of attending board meeting, it can be physically present, video conferencing, other audio visual means. Okay, then while you are attending through VC or AVM, you will have to comply the provisions related to Rule 3. The company should ensure that there is no failure of audio or video connection failures. Then company secretary and chairperson of the company has to make due and reasonable care to safeguard the integrity of meeting. They should ensure that proper equipments are available. They should be recording the meeting. They should be recording the procedure for audit and all. Everyone should be able to hear and see each other. Then next one is that they have to ensure that none other than the directors are participating. The notice should be given as per 173 subsection 3 of board meeting. Then notice should specify the option of VC or AVM. If it is not they have to specify the option of VC or OAVM. So the director can intimate the participation through VC or AVM in advance. It can also be given at the beginning of calendar year. So please note that it is not mandatory. A director can give his intimation at the beginning of a calendar year, which will be valid for the entire calendar year. So he need not give intimation at the beginning of each board meeting. That is optional. Okay. So if he is not giving any intimation, it will be assumed that he will be attending in person. So with respect to quorum, section 174 of Companies Act, quorum of section 8 company is 25% of total strength or 8 directors, whichever is less. For other companies, it is 1/3 of total strength or 2 directors, whichever is higher. So passing of board resolution can be passed either by circulation, section 175 circulation. Section 179 subsection 3 specifies certain powers which can be exercised by the directors only through board meeting. So with respect to circulation, that particular power can be exercised by a company if a particular item could not be discussed at board meeting and cannot be deferred till next board meeting, or if the item is of routine nature and the cost of conducting board meeting is very high. Okay, so the provisions which are to be discussed in board meeting, just like power to make calls, to authorize buyback, to issue security, to borrow, to invest, grant loan, give guarantee, to approve financial board's report, then to diversify business of company, then to approve merger, amalgamation, demerger, acquisition, etc. That can be discussed only at board meeting. Okay, certain powers of board under section 180, it is specified that certain powers of board which can be exercised by board meeting, board of directors, by passing special resolution. Then we have certain committees of board. We can have discussion on audit committee and nomination and remuneration committee. The provisions of this committee, the applicability is same as that of your independent director, which is listed company, unlisted public company having paid up 10 crore or above, turnover 100 crore or above, outstanding loan debenture deposit in excess of 50 crore. Okay, then vigil mechanism committee is to safeguard victimization of directors and employees, which will be applicable to all listed company which has accepted deposit from public, which is eligible public company, then companies which are having borrowing from bank and PFI in excess of 50 crore. Then stakeholders relationship committee is the committee which is applicable when there are more than 1000 stakeholders in a company during a financial year. That means 100 more than 1000 shareholders plus debenture holders plus deposit holders plus any other security holders during a financial year. Stakeholders relationship committee is applicable under 178 subsection 5. Then contribution to various fund by the board of director. 181 specifies contribution to charitable fund, political party 182, national defense fund 183. Charitable fund, you have two provisions. Means if your contribution, the amount of contribution is up to 5% of average net profit of preceding 3 financial years, you can do it the same by passing board resolution. If it exceeds 5%, ordinary resolution is required. Okay, political party contribution, there was no limit, but now 7% of average net profit of preceding 3 financial years. Then company can contribute to national defense fund. Then related party transaction, there are two kinds of approval in related party transaction: board approval, ordinary resolution. So if the transaction which is in respect of sale, supply of goods or material, the threshold is 10% of turnover. If the aggregate or individual transaction is amounting to 10% of turnover, you will require ordinary resolution. If it is related to property, 10% of your net worth, you will be requiring approval of ordinary resolution. Then leasing and availing or rendering of services, it is 10% of turnover. So you will be requiring ordinary resolution if individual or aggregate transaction in a financial year reaches 10% of turnover. Then office or place of profit more than 2,50,000 in a particular month. Underwriting in excess of 1% of net worth. Okay, now we'll move to chapter 13 of Companies Act, which is specifying appointment and remuneration of managerial personnel. So we'll be discussing the provision related to manager, managing director, whole-time director. So managing director MD2 clause 54 specifies person director having substantial powers of management. A person an individual subject to superintendent's control direction of board who is having the management of whole of the affairs of the company, manager. Then director who is in whole time employment is known as whole time director. Okay, so the provision related to appointment is specified in section 196. 196 subsection 1 specifies that no simultaneous appointment of MD and manager. Their term will be for 5 years. They can be reappointed. Reappointment can be made earlier also, but not before the 4th year. Then we have disqualification, which is specified under 196 subsection 3. Approval of board is required for appointment, and members will have to appoint in the general meeting, which is conducted immediately after the board meeting. So if a person has been appointed as a managing director by board of directors, but in the subsequent general meeting that appointment is not approved by members, the act which is done by that particular managing director will be valid. That is specified in subsection 5 of 196. Now we can have the provisions related to remuneration of this managerial personnel. So overall remuneration is 11%, which can be exceeded by passing ordinary resolution if there are more than one MD or more than one whole-time director. When we are taking together more than one MD or whole-time director or manager, taken together they will be provided, they can be given remuneration of maximum 10%, which can be exceeded by passing special resolution. If there is only one MD or one whole-time director, to that person you can give maximum of 5%, which can be exceeded by special resolution. Then with respect to directors other than MD or whole-time director, if there is no MD, whole-time director, manager in that particular company, you can give 3%, or if there is MD or whole-time director or manager, maximum 1%. So these limit can also be exceeded by passing special resolution. Now we'll move to the provisions which is related to SEBI, laws related to SEBI. So we can have the discussion on persons who are not eligible to make IPO, FPO. So we know that it is issuer, promoter group, selling shareholders who are debarred by SEBI, or if a person is director or promoter of any other company which is debarred by SEBI. Then person who is fugitive economic offender, or a person who is fraudulent borrower or willful defaulter or fraudulent borrower. Then if there are any outstanding convertible securities. We have eligibility route. We have two routes, profitability route and QIB route. If you want to issue if you want to go for IPO, FPO under profitability route, you have to satisfy 4 conditions. Minimum net tangible asset of 3 crore or above, then net worth of 1 crore or above, then average operating profit of minimum 15 crore. Okay, then if you have changed your name in the last 1 year, minimum 50% of the revenue to come from that activity. If these conditions are not satisfied, you can go for QIB route. So then conditions for IPO, you have general conditions are there, additional conditions are there. General condition specifies that you have to enter into agreement with any stock exchange. You have to appoint one as designated stock exchange. Then you have to enter into agreement with depositories for dematerialization of shares. Existing shares to be dematerialized, partly paid up shares to be made fully paid up. Then firm arrangement of finance has to be made. Then additional conditions like amount for general corporate purpose and unidentified purpose should not exceed 35%. Minimum subscription of 90% has to be obtained. If it is not obtained, the amount has to be refunded in 4 days, etc. Then prohibition of insider trading regulation, we have to understand what is the concept of insider. It may either be connected person or person having access to UPSI. So connected person who is or was having who was associated with the company during the 6 months prior to the act. Okay, if you are taking the 6 months period of 6 months prior to the act of buying or selling, a person is associated with the company because of his frequent communication, as because of professional business relationship, etc. That person will be known as a connected person. Then the provision with regard to communication, you cannot communicate, you cannot procure, or you cannot persuade communication of UPSI except in relation to legitimate purpose, performance of duties, or discharge of legal obligation. In such cases, the person to whom you have given that information will be treated as insider, and you have to monitor that person, which will be The details will be recorded in structural digital database and which will be preserved for a period of 8 financial years. Then we have disclosures, initial disclosure which will have to be done, which will have to be completed within 7 days of joining as insider. And continuous disclosure means if you are trading in a calendar quarter exceeds rupees 10 lakh, which will have to be made within 2 calendar days. Then substantial acquisition of shares and takeover regulation, we have the terms like acquirer, person acting in concert, and target company. So when the acquirer plus PAC acquires 25 percentage or more of shares, voting powers in target company, and if any acquisition if acquirer plus PAC holds less than 25 percentage in target company and an acquisition will entitle them to exercise 25 percentage or more, they have to give open offer of 26 percentage subject to non-public promoter shareholding limit of 75 percentage. If they are having 25 percentage or more already in the target company, their trigger point will be more than 5 percentage in a financial year. That is with respect to your open offer obligation. Now we will move to the provisions related to FEMA. So under FEMA, we will have the residential status, which is most commonly asked question. So residential status, we can have discussion on person. So person resident in India, PRI specifies person who has resided or stayed in India for more than 182 days. Okay, with respect to any entities which is registered in India, branch office or agency in India, branch office or agency outside India. So if a person resides or stays in India for more than 182 days in a financial year, that person is known as PRI. So certain people are not included in that list. Person who leaves India for employment, business or vocation or any other purpose in which circumstance would indicate stay for an indefinite period. Okay, then PROI, person resident outside India, means a person who is not PRI, person resident in India. Now we can have transactions of foreign exchange. There are current account transaction and capital account transaction. Capital account transaction means the transaction which alters assets or liabilities outside India of a person resident in India. Suppose if I am person resident in India, if a transaction is altering any asset or liability outside India, that is capital account. Okay, if a person is person resident outside India, if then transaction is altering assets or liabilities in India, that means that transaction is attracting two currencies minimum. Okay, that transaction is known as capital account transaction. All the transaction other than capital account transactions are current account transaction. Okay, so with respect to current account transaction, there are transactions which are prohibited by regulation, which requires central government approval, then which requires RBI approval. The prohibited transaction like traveling to Nepal, Bhutan, transacting with persons resident in Nepal, Bhutan, then remittance out of lotteries, winnings, etc. Then remittance for purchase of lotteries, banned, prescribed magazines, etc. are prohibited. Then with respect to your payment of vessel charges, then payment of your container detention charges exceeding the rate prescribed by Director General of Shipping, then foreign print media expenses in excess of 10,000 USD, then 100,000 USD, more than 100,000 with respect to your sponsorship of sports, etc. Okay, these all require central government approval. Then other than these two, you will be requiring RBI approval. So it has to be noted that with respect to RBI approval, there is a liberalized remittance scheme. So it is not possible for getting approval of RBI for every transaction other than the prohibited and central government. Means prohibited transactions are there. There are 9 transactions. Central government approval is required for 9 transactions. So all other transactions are requiring RBI approval. That is not practically possible. So the government introduced a LRS, liberalized remittance scheme, under which up to a certain limit you are not requiring to get the approval of RBI. If your transaction is beyond that particular limit, you will be requiring approval of RBI, which is specified in liberalized remittance scheme. So with respect to individuals, the liberalized remittance scheme amount is 250,000 USD, 250,000 USD in a financial year. With respect to non-individuals, with respect to donation, there is a particular limit. With respect to any consultation fee, there is an amount. Then with respect to any amount you are paying to any Agents outside India, there is a particular limit. With respect to reimbursement of preliminary expense, there is a limit. So the limit will be different for each and every transaction. In case of your non-individual transaction, with respect to individuals, 250,000 USD is the limit. So foreign direct investment is the investment through capital instruments by PROI in an unlisted Indian company, or investment in 10% or more of post-issue paid up equity capital of a listed company on a fully diluted basis. ECB commercial loans raised by eligible resident entities from recognized non-resident entities. It should conform to minimum maturity, permitted, non-permitted end users, maximum all-in cost ceiling, etc. Then we can have a discussion on the Competition Act. So we have prohibition of anti-competitive agreement, then prohibition of abuse of dominance, regulation of combination acquisition mergers, and competition advocacy. So with respect to anti-competitive agreement, you have a horizontal agreement, just like price fixing, limiting production or supply, allocation of market share, bid rigging. Then vertical agreement, with respect to horizontal agreement, it will be void under all the circumstances, and with respect to vertical, it will be decided by CCI on case to case basis. Examples of vertical anti-competitive agreement are time arrangement, exclusive dealing agreement, not supply, exclusive dealing agreement, exclusive distribution, refusal to deal, resale price, maintenance. So we can have discussion on abuse of dominance. So dominance is the position of strength which enable an enterprise to operate independently of its competitors, affect competitors and consumers in its manner in the relevant market in India. Okay, so dominance is not a problem under Competition Act. Abuse of dominance is a problem which will be prohibited under Section 4. Abuse means when they are giving discriminatory or unfair condition or unfair price, denying market access, restricting market access, restricting or denying supply, okay, making parties to enter into any other contract, okay, then using dominant position in one market to enter into another, etc. Then we can have a discussion on the combination. So combination simply means it can be merger, amalgamation, acquisition if it is exceeding or the threshold is specified in the act. So when this threshold is meet, that means if the combined assets or combined turnover of the parties who are into merger, acquisition or amalgamation is more than 2500 cr or 7500 cr with respect to their turnover. So when this threshold provisions are met by a merger, amalgamation, acquisition, you can say that it is combination. So if it is combination, approval of CCI is required. So with respect to individual, more than 2500 CR or more than 7500 CR as turnover. With respect to group, more than 10,000 or more than 30,000 as turnover. If the enterprises which are getting merged, any of the enterprise is having assets or turnover outside India, it will be in USD. So more than 1.25 billion and minimum 1,250 crore in India, or more than 3.75 billion and minimum 3750 crore in India. With respect to group, more than 5 billion and minimum 1,250 crore, or more than 15 billion and minimum 3750 crore in India. So we'll move to the provisions of prevention of money laundering. Money laundering simply means earning of income or deriving a property by committing a scheduled offense. The act scheduled, sorry, the acts, 29 acts which are specified in schedule, or which is also known as predicate offense also, okay, and projecting it as predicate, projecting it as untainted or property or money, which means you are projecting it as white money. So you are converting your black money into white money, which is money laundering. So siphoning is earning of income or deriving property by committing an offense. Scheduled or predicate offense, in part A there are 29 act, part B 132 of customs, part C cross-border offenses of cross-border implication. So under money laundering, there are three stages. So number one is placement, layering, integration. Placement means you are introducing the funds into the financial system, breaking into small parts. Okay, purchase of instrument. Layering, you are moving the funds to the distance. Okay, integration means you are taking back the fund, reintroduction of the fund into the financial system by investing in real estate, business asset, luxury assets, etc. Then reporting entity, just like bank, financial institution, intermediaries, person carrying designated business or profession, they have to report the transaction, any prescribed transaction, to the director under money laundering. Okay, then they have to comply the provision with respect to the reporting. That is, reporting entity will have to comply certain provision if they are coming across any transaction and they are of the view that that transaction is having some problem. If it is a suspicious transaction, they have to provide a suspicious transaction report. They have to report to director under PMLA, not the normal director, director under PMLA. Then they have to keep the identity of their clients and beneficial owner. They will have to keep the record of transaction which enable it to reproduce the transaction, etc. Okay, so if any transaction, if the reporting entity is getting any transaction and if they are of the view that it is not having a bona fide purpose, it is made in unusual circumstances, okay, it is not having any connection with the transaction, etc., they can report, they have to report that it is obligatory, they have to report the transaction. Now we can move to chapter 14 of Companies Act, which discuss inspection, inquiry and investigation. Please note that inspection and inquiry will be the responsibility of ROC. Once ROC is submitting the report after inquiry under section 208, that will make the way to investigation. Okay, so investigation will be made by central government under section 210, or SFIO, Serious Fraud Investigation Office, under 212, or NCLT under 213. It can be related to membership, investigation of membership, or it can be investigation into the related companies under 219. So inspection and inquiry is the responsibility, or it will be done by ROC or inspector. Then after that, after they are submitting the report under 208, inspector or ROC will be submitting the report to central government. After that, central government will be initiating investigation either under section 210 by central government or 212 by SFIO or NCLT. Tribunal will be ordering central government to conduct certain investigation, or it may be investigation into membership under 216 or into the related companies. Now we can have a discussion on the topic of compromises, arrangement, amalgamation, which is explained under chapter 15 of Companies Act. Okay, so this is chapter 15 of Companies Act. So when you have to, when the company, the arrangement, compromise arrangement can be made by company and its creditors or members. So if they want to make any arrangement or compromise with the members or creditors, the company or the members will be applying. Company usually applied to NCLT for getting the compromise or arrangement. So what NCLT will do is that when they are admitting the application, they'll ask the members, ask the company to conduct meeting of members or creditors to get their approval. So in that particular meeting, majority of the persons who have voted in favor against, that means casted valid vote, should be obtained. That means if there are 100 members in that particular meeting and 50 members have casted their valid votes, means 30% have in favor, 20% are against. Okay, so you will be counting the number of valid votes in that case. Okay, valid vote will be 50. 100 members were present at that particular meeting, but 50 members have casted their votes against or in favor, valid votes. So out of that 50, you will be taking, you should be getting the approval of majority. That means 50 valid vote means you should be getting the approval of minimum 26. That particular members, 26 or whatever the number be, they have to hold minimum 75 percentage of the value of shares or amount in the case of creditors. Okay, so representing 3/4 value to be obtained. So if in case of amalgamation under 232, if you are proposing a compromise or arrangement due to any amalgamation, what you will have to do is that you will have to comply all the provisions of section 230, plus you will have to file the same with ROC. You will have to file CAA 15 every year, which will be certified by a practicing professional till completion of tenure. Then you have the fast track merger. Fast track merger route will not be going through the NCLT route. It will be uh, a bit time saving provision. So we have an amendment with respect to the fast track merger, which we have already discussed under the session of your amendment session. Then cross-border merger amalgamation between a company incorporated in India and company which is incorporated in notified jurisdiction. Now we can move to chapter 16 of Companies Act, which is prevention of oppression and mismanagement. So lack of oppression means lack of probity and fair dealing. So which is explained in the case of Force versus Arbotle. Okay. So normally the provision, the Force versus Arbotle specifies that normally the court will not intervene into the internal affairs of the company. It is quite usual. That means the company, if they are having any issues, they can solve it themselves. If the court is intervening in their matters, after that the company is passing any unanimous resolutions, and suppose the court has removed a director, after that the particular board of directors are passing, or the general meeting is passing unanimous resolution and reappointing the same director, the order of court will not be having any value. So the general provision is that court will not intervene in the internal matters of the company. But with respect to any fraud on minority, with respect to any ultra vires or illegal act, okay, when the wrongdoers are in control, then breach of fiduciary duties, infringement of right of member, oppression or mismanagement, or if there is any action or oppression on minority, the court will intervene into the affairs of the company. Even if the application is given by one member, the court or tribunal may accept that application. So application to NCLT for oppression mismanagement can be made by 100 members or 10% of total members, whichever is less. Okay. So if that provision is not met, you will have to check whether the application is given by one or more members holding 10% of issued capital. Okay. So the general provision will be 100 members, 10% of total members, one or more members holding 10% of issued capital, whichever is less. Okay. Then we can have a discussion on the SARFAESI Act, which is a provision under the Banking Regulation Act. So with respect to SARFAESI Act, you should know what is asset reconstruction, securitization, enforcement of security interest. These are the provisions which is discussed in your SARFAESI Act. Okay. So which is specifying that just like a person is borrowing, a person X is borrowing certain amount from a bank, say suppose State Bank of India. So that amount of loan will be a financial asset with respect to the bank. So the bank will not be happy with the amount with that particular financial asset, because bank is always having a risk that that person may go as bankrupt, that person may become insolvent, etc. So the bank will be selling that financial asset to any asset reconstruction company, which is known as asset reconstruction. Then after that, that particular asset reconstruction company will be inviting or accepting amount of deposits. They'll be inviting investment from qualified buyers, which will be known as securitization. Okay. So if the amount is not paid, if any financial asset is becoming a non-performing asset, interest or principal is not paid for 3 months, it is known as non-performing. If it is becoming non-performing asset, the bank or the secured creditor, financial institution or asset reconstruction company can enforce security interest, section 13 subsection 4. Okay. So they will be first intimating, what they will do is that they will be intimating the borrower. Okay. They will have to make the payment within 60 days. If they are not making any payment within 16 days, they can take any action under section 13 subsection 4 without the intervention of court or tribunal. They can take the possession. Okay. They can take over the management. They can appoint manager. They can ask any person from whom any amount is due. They will be asking that person to make their payment to that particular secured creditor, bank or FI. Okay. Now we'll move to chapter 9 of Companies Act, which is explaining about your accounts of companies. Accounts of companies, section 128 is explaining about your location, manner, preservation, inspection of books of accounts. You can keep your books of accounts in your registered office. No particular approval is required, or any other place in India. If you are keeping your books in any other place in India, you have to pass board resolution and file the same with ROC. Manner, you can keep it in electronic mode or physical mode. Preservation for a period of 8 financial years preceding the relevant financial year. Directors can inspect the books of accounts in business hours 9 a.m. to 6 p.m. So with respect to the preparation of financial statement, it should give true and fair view of state of affairs. Then schedule 3 has to be, it has to be prepared under schedule 3. Then accounting standard has to be complied. Then reopening of books of accounts on order of court or tribunal, section 130, a person will have to, means that will be made by either central government, income tax authority, SEBI, or any other statutory body will make an application to court or tribunal. They will be taking representation from other statutory bodies, other persons, and they will be making the approval. Then recasting will be final once it is made. Voluntary revision under 131. If a company is of the view that its financial statement is not complying with 129 or board's report is not complying with 134, they can make revision once in every financial year. That means they cannot make revision more than once in a financial year, and revision can be made with respect to preceding 3 financial years. Then National Financial Reporting Authority, section 132, accounting standard will be recommended by ICAI. It will be forwarded to NFRA. NFRA will make their own recommendation to central government. Central government will prescribe the accounting standard. Then with respect to board's report, section 134, contents of board's report is there, signing of financial statement, signing of board's report is there. With respect to the contents of board's report, in rule 8 certain amendments are there with respect to your POSH Act, then maternity benefit act, etc. Okay, then CSR, corporate social responsibility, is applicable to company having net worth of 500 crore or above, turnover 1000 crore or above, net profit of 5 crore or above. Okay, so it should be consisting of directors, the provisions are there, and if the amount is up to 50 lakh, if the amount of CSR is up to 50 lakh, there is no need to constitute CSR committee. It can be taken over by the board of directors. So once the CSR provisions are applicable, minimum 2% of average net profit of preceding 3 financial years will have to be spent towards the activities which are specified under schedule 7 of Companies Act. Then circulation of financial statement, at least 21 days before AGM it has to be circulated. With respect to the listed company, the financial statement and other documents will have to be made available for a period of 21 days before general meeting, and any person can inspect during business hours. Then filing of financial statement, which is explained in 137. Okay, so within 30 days of AGM you have to file AOC 4. If AGM, the financial statement is not approved at AGM, AGM will be adjourned to next week, same day, same time, same venue. Then after that, after it is being approved, you have to, there is 2 filing. One is the provisional filing of unadopted financial statement that will have to be made within 30 days of AGM. Then after the adjourned AGM, within 30 days, you have to file the approved financial statement also. Then internal audit will be applicable to listed company, prescribed unlisted public company, private company. So prescribed means turnover of 200 or above. Then loan, outstanding loan or borrowing from bank or PFI in excess of 100 crore at any point of time during preceding financial year. Then paid up capital of 50 crore or above, or outstanding deposits of 25 crore or above at any point of time. With respect to private company, turnover of 200 crore or above, or outstanding loan borrowing from bank or PFI in excess of 100 crore at any point of time during preceding financial year. Then with respect to chapter 10, audit and auditors, you are having the provision related to first auditor. First auditor with respect to your government company is there, with respect to your other company. With respect to government company, they will be appointed by CAG within 60 days of incorporation. If they are not appointed within 30 days of in the next 30 days by board of directors, or if it is not appointed by board in the next 60 days by members. Subsequent first auditor of other company will be appointed by board of directors within 30 days if board is not appointing within 90 days in an AGM in an EGM. Subsequent auditor with respect to government company will be appointed within 180 days from the commencement of financial year. With respect to other companies, it will be appointed by AGM members. So the auditor shall hold office from the conclusion of first AGM till conclusion of sixth AGM. Then rotation, the provision of rotation will be applicable to certain listed companies and prescribed class of companies, like unlisted public company 10 crore or above, private company having paid up of 50 crore or above, then other companies having loan borrowing from uh, bank financial institution for 50 crore or above, or public deposit of 50 crore or above. Okay, then resignation, removal of directors. Auditor can resign by intimating the company ROC, CAG is if applicable. Then we can have the companies having the provision to remove the auditor by passing special resolution. We have the provision of disqualification of auditor, section 141 subsection 3. So the 140 or section 141 is explaining about the qualification and disqualification of auditor. 141 1 and 2 explains about the qualification. 41 subsection 3 is explaining about the disqualification of auditors. Then 142 is explaining about the remuneration of auditors. So remuneration includes fees, facilities extended, then expenses which will have to be rendered to the auditor. If the auditor is doing any other service at the request of the company, that will not be included in the audit fee or remuneration. Then powers are explained in section 143 of Companies Act, which specifies powers, rights of auditor, duties of auditor, powers with respect to branch audit. Means the branch audit will have to be completed by the company auditor or any other person duly qualified to become auditor. Then if it is branch outside India, by the company auditor or any other person who is duly qualified in that particular country. Okay, with respect to CAG audit, CAG will be determining the manner in which the audit will have to be completed. The auditor will be submitting the report to CAG. CAG will conduct test audit, supplementary audit, etc. Then auditor not to render certain services, section 144, just like uh, accounting and bookkeeping services, internal audit, design and implementation of financial system, then actuarial services, investment advisory, investment banking services, rendering of outsourced financial services, management services, or any other prescribed services. Then auditor to sign the audit report under section 145, auditor will be mentioning any adverse remark in that report. Auditor to attend AGM or the representative can attend AGM. A representative will have to be CA in practice. The punishment is explained in section 147. The punishment to the company, punishment to officer in default, punishment to auditor if the auditor is violating 139, 144 or 145. Okay, or if the company or officer in default is violating 139 to 146, they will be having certain other punishment. The provision of cost audit is explained in section 148. Now we can move to chapter 22 of Companies Act. Companies incorporated outside India, company or body corporate incorporated outside India, first condition, having place of business in India, whether by itself or through agent, by physical e-mode, and conduct any activity in India in any other manner is known as foreign company. So companies incorporated outside India is explaining about the foreign company. So it may be a company body corporate incorporated outside India, having a place of business in India, whether by itself or through agents, whether by physical or e-mode, and conducts any activity in India in any other manner. So if it is a foreign company, these provisions, section 380 to 386, 390 to 93 will be applicable. If 50% or more of the paid up capital of the foreign company is held by Indian citizen, body corporate or companies incorporated in India or jointly by Indian citizens and body corporate in India, they will have to comply this provision 380 to 386, 390 to 93 and such other prescribed provision as if they were an Indian company. Okay, then we will move to the provisions relating to cyber law. So under cyber law, we have sensitive personal data rules. Okay, so personal data means the data from which the identity of a person can be obtained. Sensitive personal data means the data which is like your password, ATM pin, credit card, CVV number, then health report, sexual orientation, etc. Okay, so while you are collecting any sensitive personal data, you will have to make a draft of what you are collecting. You will have to upload the same. Okay, when you are collecting a data from a person, that person should be made aware of what you are collecting, for what purpose you are collecting, then for what use you are making that, and you should not use it for any other purpose. You cannot use it for any longer period. For if you are using for any other period, for any other purpose, you will have to take the approval, permission. Reasonable security practices have to be adopted. Then BI, business intelligence, means technology driven process in which the data is being taken from some other outside sources and meaningful information is being given. Okay, So it is also known as, or it is having the provision of data privacy, which means under business intelligence you are taking data from some outside sources, you are having some data, you are correlating this data, and you are making some meaningful information. Okay, so business intelligence can be, there are different features of business intelligence, like ad hoc intelligence is there. If your BI tool is giving your solution to any ad hoc problem, online analytical processing, if it is giving solution to complex issues, then mobile BI is there, which is available on tablets, mobile, etc. Real time BI, in which the data will be updated on real time basis. Then operational intelligence, which will be the data BI tool which is used by operational managers. Open source business intelligence, in which a free version and premium version is available. Then you have collaborative BI, embedded BI. Collaborative means you are collaborating some features. Embedded means that BI tool is embedded into any other system. Geographical intelligence, geographical BI means the location data is available. Then cyber crime, cyber crimes in which the computer is used as a tool, target or place of criminal activity. Cyber crime can be against person, cyber crime can be against the property of a person, then against the government. Against person may be cyber stalking, making any physical threat, obscenity, uh, indecent exposure, then defamation, lowering the dignity of a person, unauthorized access like hacking, cracking means stealing, spoofing, act of disguising the communication, credit card uh, frauds, then fraud, threat, etc. Squatting means any intellectual property, you're creating an intellectual property with the same as an existing property. Then vandalism, any external system is entering your system and destroying the same. Hacking, virus, trespass means unauthorized access. Then terrorism, warfare, piracy, unauthorized information with respect to the cyber crimes against the government. With respect to the provisions related to MSME, there is an amendment with respect to the definition from 1st of April 2025, which is specifying that in respect of your micro, the investment in plant and machinery or equipment should not be more than 2.5 crore and not more than 10 crore. With respect to small, not more than 25 and not more than 100 crore. Medium, not more than 125 crore and not more than 500 crore. So while computing the investment in plant and machinery, you will not be taking into account the investment in land, furniture and fittings, etc. And while you are computing the turnover, your export turnover will be excluded. So while you are discussing about the payment to MSME, the payment to MSME will have to be made on or before appointed day. Appointed day means, sorry, agreed day. The date which you have agreed. The agreed day which should not be beyond 45 days. Okay, if there is no agreed day, it will have to be paid on or before appointed day. Appointed day means day after 15 days from the date of providing service or deemed service. Okay. So in case of delayed payment to MSME units, they will have to pay interest at the rate, compound interest at the rate of 3%, 3 times of your bank rate, and the details will be that will have to be attached to your audited financial statement that you have delayed any payment to MSME. Okay, then we have the provision related to insolvency and bankruptcy code. Insolvency and bankruptcy code, under this provision, the application to NCLT can be made by the financial creditor, which will be under section 7. It can be made by operational creditor, section 9. Then it can be made by corporate debtor under section 10. Okay, so the procedures are, they will be making application to NCLT. NCLT may accept or reject the application. Before rejecting, they will be giving a defense opportunity to rectify the mistake in 7 days. So once they are approving the same, they will be issuing, NCLT will issue a moratorium. Then they will issue public announcement. They will appoint interim resolution professional under section 16 of IBC Act, IBC 2016. Then IBC, the process, CIRP, corporate insolvency resolution process, will have to be completed within 180 days from the date of commencement, date of admission. Then one time extension of 90 days will be granted by NCLT on certain terms and condition, and which will have to be completed within 330 days, including the time taken for any legal proceeding. So the duty of interim resolution professional will be to constitute committee of creditors. So after committee is constituted, what will happen is that the committee will elect either, they'll appoint either the interim professional or they'll appoint any other professional as insolvency resolution professional. So insolvency professional will be preparing the information memorandum, and it will be provided to resolution applicant. Resolution applicant will be making resolution plan. That resolution plan will have to be approved by 2/3 majority, 66% majority of committee of creditors, and which will be submitted by insolvency professional to NCLT. So if NCLT is accepting, that is done. If NCLT is rejecting, NCLT will order winding up of companies. Okay, so then we will move to the provisions related to corporate governance. Corporate governance simply means achieving the objects of organization by considering all the stakeholders. So it is complying the provisions in true letter and spirit. So with respect to your corporate governance, we have a discussion on the difference between ethics and corporate governance. So ethics means inner self and of an organization which is reflected, inner self of a person which is reflected at the workplace. Corporate governance simply means it is a means to achieve the result. Okay, there is a difference between management and corporate governance. You have the corporate governance, this governance system. In the family business, you have the provision of sustainability. Sustainability means you are achieving the results of an organization by considering the future generation. You have the evolution of corporate governance. Okay, then you have the provisions which are related to CSR and corporate governance. So these are the topics which are covered under the head corporate governance. So simply means corporate governance means you are achieving the organization's objective by considering all the stakeholders. Okay, so these are the provisions of the chapter. I have gone through the majority of the chapter, majority of the provisions of the chapter. I cannot say that I have completed the entire topics. The time is limited. You have your exam within 2 days, so I have gone through the entire topics in a very fast manner. Okay, so I think the discussion is clear to everyone. Okay, if you are having any queries, any doubts, you can contact me, and all the very best for your examination. Thank you.